Hi, everyone. Thanks for coming to the webinar today. I'm going to try to get through this as quickly as I can because we've got a lot of states, a lot of new laws here, and so we'll try to cover everything. Arkansas is the latest state to pass a Crown Act, which prohibits discrimination against cultural hairstyles. Your jurisdiction probably has one of these already, so, and if they don't, you shouldn't be discriminating based on hairstyle or hair texture that's associated with race anyway, uh, regardless of whether you have a Crown Act, but Arkansas just passed one. California, the Fair Employment and Housing Act just was amended to protect applicants from discrimination based on prior cannabis use. And employers are prohibited from mandating attendance at employer-sponsored meetings about religious or political matters, including union matters. So states can't force employees to attend meetings about political issues or unions. California, a temporary layoff with no projected return to work date is considered a discharge and triggers California's final pay laws. This applies to temporary assignments as well. If you have someone who worked a temporary assignment and you don't see yourself having an assignment for them in the future, that triggers final pay laws and they need to be paid on the day the assignment ends. Reimbursing employers, they need to be reimbursed whether the expenses were a direct consequence of the employee's job duties, not on whether the expenses were caused by the employer. So anything that they ring up through doing their job is going to be reimbursable. It's not going to turn on whether or not you directly cause them to incur the expense. California has some new templates and posters. You can find these at the addresses here. And also we partner with Poster Elite. Poster Elite helps keep you updated with all state and federal posters. They keep you evergreen with a subscription, and you always have what you need for state and federal from Poster Elite with the subscription there. So, but these can be found on the DIR website. You just have to make sure you're posting these. It is now an unlawful employment practice for an employer to refuse to grant a request for 5 days of reproductive loss leave, and it defines here what reproductive loss leave is, and employees must receive notice. This needs to be in your employee handbook about reproductive loss leave. New laws in California ban certain non-compete and non-solicitation agreements and require you to notify current and former employees in writing that prior non-compete agreements are void, the ones that contradict the law. So you will have to notify employees with prior agreements that their agreement now is void. The entitlement to annual paid sick leave was increased. The number of days that California employers are required to provide to employees has gone up from 24 hours to 40 hours. So you want to make sure that you are keeping track of paid sick leave and making sure that your employees are getting the right amount. And San Francisco passed a city ordinance related to military reservists. The California Consumer Privacy Act has expanded the definition of sensitive personal information to include consumer citizenship or immigration. So if that gets disclosed, that is a violation of the CCPA. The new Workplace Violence Prevention Act. This law requires, you can see the requirements here, for the new Workplace Violence Prevention Act. There will be training. There will be implementing a plan that needs to be in your handbook. There's record keeping regarding your plan. Right now, I think DAR is not providing any training. I think there are companies that provide workplace training that are now providing this training to employees that you have to purchase. But I don't think DIR has an example yet, but it's not in effect until July 1st, 2024. So if you wait a little bit, DIR might come out with a free training, but right now you would have to go through a private agency. But again, this plan must be in the employee handbook. Colorado, their workplace kind of drops the bar for what can be considered actionable harassment. It lowers the severe and pervasive standard to any unwelcome conduct. So you are going to probably have to change your sexual harassment policy in Colorado, have that in the handbook, and just be aware, have managers and supervisors looking out, reporting conduct, sexual harassment conduct, and then there are also limitations on non-disclosure and confidentiality provisions in employment agreements. Those are not separation agreements, employment agreements. If you violate this and you put the wrong restrictions, put prohibited restrictions in these employment agreements, you will face a penalty for violating that. The Colorado Healthy Families and Workplace Act, that's the Paid Sick Leave Act, included bereavement leave and inclement weather in the reasons for using paid sick leave. Colorado's equal pay transparency law has changed a little bit. This is the law that requires you to provide notice of salary information in a Colorado job posting. This also has to do with informing employees of the who exactly the candidate was that got selected, their job title, how employees can demonstrate interest in similar job opportunities in the future. And if a position has career progression, they have to disclose that to all employees, and they will no longer have to provide employers with physical locations outside of Colorado with Colorado employees notice of remote job opportunities only, not promotional opportunities company-wide. Florida, if you have 24 or more employees, you are required to use E-Verify now. Georgia, your non-solicitation agreement has to have a territorial provision, so such as employees can't solicit customers within 20 miles of the work site to be valid and enforceable. You've got to have that that geographic area in your non-solicitation agreement for that to be valid. Hawaii, another pay transparency law disclosing hourly rate and salary range in job postings. They have lowered the bar on discrimination as far as their Equal Pay Act. So normally the Equal Pay Act prohibits paying employees less for doing equal work. Now Hawaii has dropped the bar to substantially similar work. Illinois has enacted, or excuse me, Chicago has enacted an ordinance that prohibits employers from discriminating or retaliating based on reproductive care or gender affirming care. Employers cannot access their information. They cannot require employees to waive their right to make decisions about reproductive or gender affirming care. The Day and Temporary Labor Services Act is going to go into effect on April 1st, 2024. And this has to do with temporary agencies paying their laborers at least the same rate of employment, rate of pay and equivalent benefits as the lowest paid direct hire at the client company. And there's record keeping and registration requirements for this. This we can go into detail a little bit more. If you are concerned about this, you can always open a ticket. And this may be a topic for a future webinar because I know this is something that staffing and temporary agencies are really concerned about. So the Cook County Ordinance, Illinois passed a Paid Leave for All Workers Act, just like with the previous Paid Sick Leave Act. Cook County and Chicago had their own ordinance. You should use whatever ordinance in your jurisdiction is more employee friendly to the employees. So Cook County is a little different than the state of Illinois. And Chicago, the same. I'm not going to read everything on this slide, but Chicago is more employee friendly than the new Illinois Paid Leave for All Workers statute. So if you are in Chicago and you want to make sure that you've got this in your handbook, first of all, second of all, that you are following this most employee friendly version of the law and not just the Illinois state law. And this is the Paid Leave for All Workers Act. So this is leave for any reason that employers must earn a minimum of 40 hours in a 12-month period, and that can be used for any reason with 7 days notice. Or notice as soon as practicable. And so this is, you can't turn down an employee's leave no matter what the reason is. You have to grant leave, not just sick leave. So this is the new Illinois law. And again, we've had questions about this as well. Illinois extended their Child Bereavement Act for employees who have lost a child due to suicide or homicide. And this just increases the amount of leave in this case under their Child Bereavement Act. Chicago has a new ban the box ordinance. This is there are kind of two ban the box ordinances. There's one not asking about criminal history until you've extended a conditional offer, and then there is what's commonly called a Fair Chance Act. And a Fair Chance Act requires you to analyze whether the conviction relates to the job and other factors relating to the conviction, such as the length of time and evidence of rehabilitation, mitigating circumstances. All that must be considered before you can turn down an applicant based on a criminal record. And so this is just more of that Fair Chance Act. You have to still provide pre and post adverse action notices, and you have to provide written notice of your decision and the reasoning for your decision. And that's with Chicago. Evanston, Illinois has enacted a Fair Work Week ordinance. I don't know if anyone operates in Evanston, but they will have a new ordinance requiring you to employ or provide employees with their work schedules, their and advance notice if a work schedule is changed. Family. So as far as scheduling, families or family members or victims of domestic violence may request that their personal schedules may not be posted or transmitted to other employees. Employees have the right to rest, including the ability to decline work hours within their 11 hours of their last shift. This applies to employees in the building services, hospitality, manufacturing, restaurant and food service, retail and warehouse industries. And so this is something that I think applies to a number of our clients. Indiana, this non-compete agreement applies to physicians only. So if you work with physicians, this will apply to you. And Iowa, same thing with the mental health professional. It bars non-competes with mental health professionals. So if you're working with mental health professionals, this is something you have to pay attention to. Kentucky has become the 38th state to legalize medical marijuana. No cardholder protection is available under the law, so you do not have to make a reasonable accommodation just based on the use of marijuana. You don't have to allow a positive drug test just because medical marijuana is legal. So you don't have to. You can still fire someone for a positive drug test, even if it is medical. So it looks like I got you done in 20 minutes here. Like I said, like Dan said, you will get a copy of the slide deck and a copy of the recording, so you can look through that if you want to take more time to go over that information. Of course, you can always open a ticket in our Ask an Attorney portal if you have questions, and if you're not a client and would like more information on how to comply with things like this with annual state updates, you can email us at info@myhrcouncil.com. So thank you all for participating today. I hope everyone enjoys the rest of their day.